Welcome to Epstein Becker Green's Employment Law This Week podcast. I'm George Whipple. Courts limit the reach of nationwide collective actions. In Harrington v. Cracker Barrel, the Ninth Circuit ruled that federal courts must consider personal jurisdiction before allowing plaintiffs to send out notices to out-of-state employees in FLSA collective actions. The decision aligns the Ninth Circuit with the Third, Sixth, Seventh, and Eighth Circuits. It extends the logic of the Supreme Court's Bristol-Myers Squibb ruling, which narrowed the scope of specific personal jurisdiction in mass and collective actions to FLSA claims. Epstein Becker Green's Courtney McFate tells us about the Ninth Circuit case, which could have big implications for employers facing FLSA actions.
Harrington versus Cracker Barrel involves a collective action based on a wage and hour related claim that the employer, Cracker Barrel, violated the Federal Fair Labor Standards Act by underpaying its tipped employees. In this case, the issue of personal jurisdiction and the court's ability to authorize notice to potential plaintiffs took center stage.
The Ninth Circuit held that out-of-state notices should never have been sent because courts cannot hear FLSA collective claims unless there is a meaningful connection between the forum state and the claim.
Harrington v. Cracker Barrel has several positive implications for collective actions proceeding under the FLSA, particularly for employers with operations located in multiple states. The key impact is that it will be harder for plaintiffs to bring nationwide collective actions anywhere except where the employer is headquartered or principally based. Employers also now have stronger grounds to challenge out-of-state employees' inclusion in collective actions where their claims have no connection to the state where the collective action is venued.
Under this ruling, courts will be required to conduct a jurisdictional analysis before authorizing nationwide notice in FLSA collective actions.
Employers and their counsel should take notice of the jurisdiction in which a collective action under the FLSA is filed and the locations of the employees who may become potential plaintiffs in that action, so that they're prepared to raise the jurisdiction issue with the court and opposing counsel, particularly before nationwide notice of the collective action goes out. Employers should also be aware that notice to potential plaintiffs in an FLSA collective action will go out to any potential plaintiffs who might be subjected to an arbitration agreement. In other words, where there are still issues of fact regarding the arbitrability of an employee's claim.
This ruling applies to employers that have arbitration agreements with their employees and those who do not. Thanks, Courtney, and thanks for listening. We'll see you next time.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.